Hello, everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we are lucky to have Rebekah Ryersee with us, licensed paralegal with a good standing with the Law Society of Ontario, to talk to us about a very important issue, which is the maintenance issues under the Landlord and Tenant Act. Rebekah, thank you very much for being here today with us.
Thank you, Heath, for the wonderful introduction, and good evening to everyone. My name is Rebekah, and I'm a licensed paralegal in Ontario. My practice focuses on small claims matters, provincial offenses, but especially landlord-tenant issues. Today's presentation is part one of a series of 3 on the Landlord-Tenant Board. We have provided a copy of this presentation material so you can follow along. There's resources, websites, links that are active, and that'll all be available at your fingertips if I go too fast. Now I'm just going to share my screen really quickly for everybody. Just got a quick little presentation here. And there we go. Please be advised this presentation is for informational purposes only. It should not be considered legal advice. If you have further questions or require legal advice, please contact paralegal. So the topics we're going to cover today is who's responsible for maintenance, and these are our rental units. What do you do before you go to the board? The forms and rules used, and what are the next steps? And finally, we'll end up with some questions and answers. So let's begin, shall we? First question you must ask is whether your unit falls under the Residential Tenancies Act, or what we call the RTA. If you're in shared accommodation, or what we used to call a rooming house, you're not covered. So shared accommodation is where you have your own private bedroom that you can lock, but everybody uses the kitchen and bathroom. Condos, trailer parks, or commercial properties are also not included in this presentation because they have their own set of rules and sometimes are just not covered under the RTA. So what does the Landlord-Tenant Board do? Well, it's a tribunal overseeing any issues that both parties might have. These issues are brought to the board through an application, considered by an adjudicator, and that is done through what they call a tribunal hearing. So it might not be as formal as a courtroom, but there are processes that you have to follow. Forms need to be accurate. Something as simple as a date can have the file thrown out. So this is why we always suggest that you read the instructions first and get help if you need to. On the other side is the Governing Act. So that's the Residential Tenancies Act. This is where the rules are, what we follow. So let's move on. Who is responsible? Well, the landlord's responsibility to repair. I'm reading this directly from the RTA. A landlord is responsible for providing and maintaining a residential complex, including the residential or the rental units, in a good state of repair and fit for habitation, and for complying with health, safety, housing, and maintenance standards. Let's break down that paragraph. In a good state of repair, fit for habitation, and complying with standards. Here I've listed just a few of the things that are considered the term vital services. Electricity in the home, plumbing, heating systems, and if it's in the lease agreement, if the fridge and stove were included, they need to be in working order. Carpets and flooring need to be safe, basically sanitary, and free from, let's say, tripping hazards. Exterior doors are important because they keep you safe and secure. This includes windows, walls, and even the roof. Now, a tenant has a right to reasonable enjoyment and a safe environment. In addition to all these things, Infestations need to be treated. That's the landlord's responsibility. And lawn care, including snow removal. You might make arrangements with your landlord that you're going to clear the walk, but he needs to ensure that you are doing that. And this leads us to the responsibilities of the tenant. A tenant must keep the rental unit clean, up to a reasonable standard that most people would consider ordinary, normal cleanliness. If a tenant's unit is so unclean that it's interfering with the reasonable enjoyment of the landlord or other tenants, the tenant could be evicted. Now, you also must repair or pay for the damage to the rental property that's not due to what we call normal wear and tear. And you're going to hear the terms reasonable and wear and tear quite often during this presentation. The damage could have been caused by a tenant. It could be guests that you invited to your property, or even your pets, animals. You're required to keep the unit clean, and some people's definition of clean is slightly different than others. So I'm going to give some general examples. Let me for a second here. First, I want you to always take photos. Do it from the day you move in. This sets the standard of what it was like, and this is how you have to return it. So let's say in the future you complain about the flooring and the landlord says the flooring's just fine. Or he complains when you check out, you ruined this carpeting. You can say, but this is what it looked like when I got it. So always record these things. Examples of clean. You're a single parent. You have a couple of kids and toys are strewn all over the floor. There might be laundry piled up on the couch and dishes in the sink. This might be considered messy, but it's not necessarily unclean. But another example is household garbage piled up in the kitchen, mold and rotten food left all over the apartment, both of which would increase the chances of a bug infestation or even rodents. This would be considered unreasonable. Damages, like I said, are the responsibility of the tenant, and they're not limited to holes in the wall or stains on the carpet. They could include excessive noise, smoking, or even harassment from loud music. Essentially, everyone has a right to reasonable enjoyment where they live, and owners have a right to have their property reasonably maintained. I'm going to take a moment to go over a few scenarios, and then we're going to get into the proper way to address these issues. One question I hear a lot: furnace filters. Who's responsible? Well, I'm going to break it down for you. The furnace is used to heat the home. That's a vital service. The furnace filter is not required in the heating process. So should the filter be changed? Manufacturers, they do it 3 times a year. Absolutely. But since the filter itself is not a requirement to provide heat, the landlord's not required to change it. From what I've seen, most reasonable and responsible landlords will do inspections. They'll come and change the batteries on your smoke alarms. They need to make sure that those are maintained. They will probably do the furnace filters at the same time. But if it's not happening, you want to improve the air quality in your home. Think of the filter as a light bulb. Just change it as needed. But it's not the responsibility of the landlord. So we've mentioned before wear and tear. And this is a question that I seem to get a lot. Excuse me. Wear and tear is a normal breakdown of a product over time. This term mostly applies to fixtures in the house. And what I mean by that is carpet and flooring, paint on the walls, and plumbing. Those are just a few examples. The RTA does not define the length of time that constitutes as wear and tear. So that goes back to that term that I used, reasonable. That's how the law works. What would a reasonable person do? If you feel that the carpet and the flooring is starting to look old, remember, this is your opinion. It's not a vital service required for the unit, but this could be considered a safety issue, and let me explain. If, say, the tack boards around the carpet are starting to stick up because the carpet's getting really thin, or maybe there's a rip along the seam and kids are tripping on it, these are issues that you would bring up to the landlord. But it's also up to the landlord whether they replace it wall to wall or they just repair the specific area. Again, it's all about opinion. When it comes to the way it looks, the landlord just has to meet those standards. If you walk into your bathroom and the tap is leaking and you're like, just got to replace that, again, it's up to the landlord, because as long as he's providing you with working plumbing, that's all that's required. Excuse me. They might repair it to stop the leak or replace it, but it's not up to the tenant. If the tenant replaces that fixture, that goes back on the tenant. Both scenarios are also good examples of putting the other party on notice. If the issue is not resolved and you need to move to the next step, you need to prove to the board that you made attempts to negotiate. So I'll give you a hint. I did before. Take pictures, take video. This might seem, I don't really need to do this because I know I'm just going to text my landlord and he's going to show up. Do it anyways. Keep it on a file on your computer. You never know when you might need it. Or you might need to show it to the landlord. And also, when you're sending the request, make sure it's in writing. Put things like, I'm contacting you about this issue. It started on this day. This is becoming a problem. If they ignore you and they're not responding, make sure you say, this is the second request, or maybe it's the third request. But you make sure that you let them know that you contacted them before. I'm just going to go back to sharing my screen if you don't mind. I'm going to go back to the presentation. Skip over to, oh, it loves to do this to me. Just give me a second here. There we go. From current slide. Before you apply to the board. So remember what I said, notify the other party of the issue in writing. Text message, letter, email, all of these are acceptable. Email is the best because you can actually timestamp it. But you also have to allow the other party a chance to respond. On each notice, indicate whether it's a first request or second request. Document every communication, including a no response, and gather evidence of your claim. Now, applying to the board costs money, and currently it's taking an unreasonable amount of time to get to a hearing. So take your time and consider whether the issue could be resolved in other ways. Negotiate, talk to them. If they're not doing anything, you need to know. You need to move on to the next step. Tenants put a landlord on notice through those communications I was just talking about. The landlord uses forms provided by the board. They have to be official. Now, what happens if your bathroom, specifically the commode, is not working and you can't fix it? You've tried everything. You need to move to the next step. But the landlord says, I'll have somebody out there tomorrow. They don't show up. I don't know about you, but no, I am not living longer than 24 hours without that specific vital service. So there's another way you can do it. If you feel the landlord maybe in the past has ignored these things, you know that this landlord's not going to do anything. There's something called the Residential Housing Enforcement Unit. When you contact them, you let them know how many times you've called, emailed, text message to the landlord. I need to get this fixed. They are going to ask you a bunch of questions and make sure that everything's covered. And what they start with is if you are eligible, and I don't mean financially, I mean like all the T's have been crossed and I's dotted, they will get involved. And quite honestly, they are an enforcement unit for that reason. That is not something that in Canada you need to go without. So if you need to, and it's a vital service, go ahead and contact them. If you're looking for them to supply paint because you don't like the color, that's not where you're going to go. Also, in my presentation, I provided you a link to legal aid. If you ever got to the point where you might be evicted, contact legal aid, see if you're eligible, do your application. I'm not going to get into detail about it now because that's more of a personal thing as to whether or not you will be approved. But I do suggest looking into it. I provided you a link. Give me a quick second. I'm not going to go into detail about these forms and rules, and there's a reason for that. They're complicated. But what I'm going to tell you is, on the landlord side, the landlord is going to issue you a notice. A notice is in an official form. So as a tenant, don't panic because a landlord needs to do this for you. It's called an N5. So if they walk into your house and there's interior doors that are damaged and you've ripped up the carpet and garbage is just strewn everywhere, this is something that they would issue this to you for. Again, don't panic, but there are several different reasons. Illegal acts, damages, and what they call reasonable enjoyment. So for any of those reasons, they give you a T5, or excuse me, an N5. That means that it's going to say that they're looking for eviction. They want to end your tenancy based upon these damages. Okay, so if you fulfill it within 7 days, you fix all the damages, you take care of everything, it's settled. But if you don't, they can apply for what we have shown you here is an L2. Again, read the instructions first, and maybe even as a tenant, you can read the landlord's instructions. So I've got a tenant. You've already sent communications to, I'm so sorry for my dog. You send your notices to the landlord, you've sent communications, you're being ignored. You know for a fact, you've looked it up. I need you to have this taken care of. Nothing's being done about it. You can actually apply for what they call a T6. I've put the links in here and the link to the instructions. Follow along, read it, and if need be, get help from a paralegal, because you could get an order to comply with these maintenance standards. Let's move on. What if you disagree with the notice? This is one of the most important parts, because I had somebody once say to me, I got a T5. Oh, I might not have been screen sharing. I'm sorry. That's okay. You got it on PDF. I had a tenant who said, I got this notice and it says my dogs are barking, ironic, all night. She didn't own dogs. Do you ignore it? I'm going to suggest that you do not, because you're being accused of something you didn't do. So notify your landlord you do not own dogs. That's time stamping it. That's saying that at this date and this time, I don't have dogs, and I'm letting you know. So just as you can see, I was going to say about screen sharing again. Apparently I wasn't doing it before. We should be doing it now. I'm also not going to follow through on this. This is just sort of a summary of what we talked about. If you have any questions, we're going to be coming up to them just about now. And I want to show you this. This is a summary. What the Landlord Tenant Board does and what the RTA is. Landlords have a right to evict your tenants that don't pay the rent in full or on time. They disturb other tenants that might cause damage to the unit. But tenants also have a right to disagree with the notices and wait for a hearing. Tenants, on the other hand, have a right to reasonable enjoyment. And therefore, if they need to, they bring it up to the landlord, and it's about maintenance. So now that I've gone over that, let's get into who is responsible and who's responsible for what. So I talked about furnace filters. What about if you lost the keys to your mailbox? You know, those community mailboxes that we all seem to have. You were probably given that key when you moved in. It's your responsibility as a tenant to replace it, because you're going to need to hand it over to the landlord when you leave. Is my landlord responsible to clean the outside of my windows? No, they're not. If you're in a multi-story tower, they'll probably do that once or twice a year. But are they responsible for that? No. Who changes the batteries in my smoke alarm? Probably you. If there's an issue and you can't reach your batteries in the alarm, please notify your landlord, because it's their responsibility to make sure that they're working. But why can't you just go fix it? Like I said, it's like a light bulb. Now, an interior door falls off its hinges. Why did it fall off the hinge? Did you run into it? Or did it literally, my kid, he's 6'2", 20 some odd years old, walked up to my bathroom door and literally, with the force of it, took it right off the hinges. We fixed it, but we contacted the landlord first to let them know this is what happened. Is it okay if we fix it ourselves? That's considered damage by the tenant, by the way. You're responsible for it. And I'm just chiming in here. Etham, do you have any questions for us? No? Okay.
Yes. Yes, we do
Oh,
have
yeah?
a question. Oh, yeah, I actually put it into the chat.
All right, I'm going to check that right now. I'm going to stop
yes.
sharing my screen. Let's take a look here. When I moved in, not all sconce covers were on the walls. Yeah, I know, a semicircular cover. I decided to make my own covers, and they are safe. The light bulbs that need to be replaced and are very expensive. Am I required to cover the cost of the bulbs? You know, I'd have to look into that. I would contact your landlord first and let them know that it's burnt out. Remember, we said that they provide electricity to the home. They don't necessarily have to make sure all the lights are working. They need it for safety. So if it is in a common area and it needs to be well lit, maybe a dark hallway that you have to go down to get to your door. If it's a safety issue, yes. If it's something that maybe highlights the fireplace and looks really great on either side. I know about light bulbs, and I know that they're not the regular 50-cent ones. They do cost a bit of money. But if they were working when you came in and you started your tenancy, you're going to have to make sure they're working when you leave. Maybe putting that bill out there, ask your landlord, would you pay for them? And if they don't, and you want them to work, I would definitely go ahead. All right, any new messages?
Well, actually, I do got a question. What if I was trying to fix something on my own, but this lead us to ruin something else? So, for example, what if I was trying to fix something in the window and then all of that window smashed?
Okay. So, originally there was a problem. You were trying to fix something. So I would ask, did you contact the landlord, sorry. Did you contact the landlord and put them on notice that there was an issue in the first place? Did you give the landlord a chance to come over and reasonably repair it? If you're answering no to these questions and you made the decision on your own, now you've got a problem, because a landlord's going to come over and go, somebody been working on this? you have to let them know. So just like that door, I could have made it worse. I could have tried to glue the hinges on. I could have put screws that were this long in instead of the normal, well, they should be closer to that long to get into the solid wood of the frame. But if you've notified the landlord and he says, yeah, just go fix it yourself, you're handy. Remember, like I said, keep it in writing, because it's vitally important that he allowed you to do that. He said, go ahead and fix it yourself. So now you tried and it didn't work. So you call the landlord and said, yeah, what I tried didn't work. So you're going to have to come over. But remember, keep it in writing and take pictures.
What other evidence that I might have if I don't have pictures? Would witnesses, for example, work before the landlord and tenant board?
They absolutely do. Absolutely. Witnesses are like a camera. Okay, they're like a video. They're remembering everything that they saw, anything that they've heard. So if you have a neighbor that overheard your conversation with your landlord, because I don't know about you, but I just don't think I'm going to pull out my camera. I kind of find that rude, to record it. But in that circumstance, you can call up that witness, that neighbor of yours, and say, listen, I've got this issue. There was a day that you were over at my house. Did you listen? Did you hear? Would you please be a witness? And sometimes they will and sometimes they won't. But that works just as well as photos and evidence.
So another question, how long it might take in average to file something related to maintenance with the landlord and tenant board and getting a response? Some things are really urgent. Would it take, please?
Exactly. And that's a good question. All right. I can't say for sure because it depends. And when I say that, it means the roof is leaking, it's pouring water, it's just about to be winter. That's going to be a maintenance issue that needs to be addressed now. You can't wait 7 or 8 months till next summer to get a hearing on this. So if your landlord's ignoring you, the property manager, you're not getting the results that you need, you are going to file. But remember what I said about the RHEU, the Residential Housing Enforcement Unit. Give them a call. I don't want to scare anybody, but we're talking about major fines if the landlord doesn't comply within a reasonable amount of time. So like I said, you've got a roof leaking. This is something that needs to be taken care of right away. Contact them, because an application to the board, that notice that I told you, that what was it, a T5? I've already forgotten. A T6. When you're going to the board for that, you might be going after damages, as in it ruined the carpet, you need to get that replaced. They might fix the roof, but all your, like not so much contents, because that's contents insurance you need to have, but you might need to say, but they didn't fix the wall. And behind that wall is where the water came in. Now it's starting to come up underneath my carpets. So start there and then move to a T6. Now, the question was how long? What my colleagues and sort of word on the wire is, maintenance issues are being heard. They're one of the first ones to be heard, but still it can take 3 or 4 months to get that hearing. So you make your application, you get a hearing date, usually within a month, and then you have another 3 months or maybe 4 to wait to get to that hearing. Other ones that we're not going to cover today are taking a lot longer than that.
Last but not least, what if my landlord intentionally ruined something just to annoy me? For example, did something related to the heating during the winter, something related to the electricity.
Oh, well, here we go. Remember what I said, heating is part of the vital services. Your landlord needs to make sure that it is at a certain temperature, and months are, I'm trying to remember, don't quote me, but like September, maybe October 15th. And the latest would be, I think it's April. Okay. So they need to provide you with a certain temperature in that unit for those months, meaning that if it drops below, so what I think you're saying is they're playing with the thermostat, keeping it like really low, like 60. Yeah, they can't do that. That again, that falls under an N6. So you would file, or you can contact the RHEU because it's a vital service. Just like water and electricity, they need to provide that to you.
Thank you very much. So another question, what is there any available resources where people can educate themselves on those issues available online or anywhere?
So are you, just so I can clarify the question, they're asking if there's anywhere online that they can find to take a look at these issues?
No, if there is any, for example, an article or a video that explain all of those issues so people can read them as a reference before they started the official process.
Not one that I could, off the top of my head, think of, except for one, but I don't know how specific. I was going to bring that up in another part of our series, so I invite people to join that. It's called Navigating the Landlord Tenant Board. And part of that is what they call the portal. One of the, and let me see if I can't find it here really quickly, but one part on the Landlord Tenant Board website is basically a questionnaire. I love it, to be honest. It gives you, it starts asking questions. Are you the landlord or tenant? Let's say you're the tenant, and then it asks you another series of questions. Are you covered under the RTA? And eventually you get to a point about maintenance, and you would click on something exactly like that. I have an issue with this, but what I think you're looking for is a listing of all the maintenance issues. There are so many, I couldn't. So what you're going to do is remember the term vital services. Vital services, electricity, heat, plumbing, okay? Door locks, safety, those things. Those are vital services that must be. If there's a question, you're kind of getting into too many details, but what about my carpeting? A window doesn't lock and you're on the ground floor. That's a safety issue. But as for an absolute listing, there's just too many. But Google has helped everybody. So take a look and see if your problem, number one, is covered under the RTA. Number two, if you can do something with it at the board. And number three, contact the RHEU. But it would be about something specific. I hope that helps.
Thank you so much. And I'm here inviting everyone who's following us and watching us now on the several social media platforms. If you have any other questions, please type them into the comments, into the chat, and they will be answered accordingly.
Absolutely. Let me go through a couple other questions that I have. I found these all on Facebook groups that I joined. What else did we talk to? One I just saw today, my hot water heater stopped working and the landlord needs to replace it. But he came to me and said that, hey, let's go halfy on this. You pay for half and I'll pay for half. Absolutely not. The tenant is not responsible for a fixture. That means If your tap breaks in your kitchen and the landlord has to replace it, you're not paying for half of it because you don't get to take half of it with you when you go. You have to leave it there, obviously. So the question about this water heater, and again, no, you have the benefit of using it because it's part of the vital services. So if the landlord's asking you to pay for half, no, you don't have to pay for half of that. Another one was my dog chewed the stair banister. Okay, listen, that's destruction. You're going to have to pay for that. I had a landlord, and just very quickly, get bylaw notices because they were putting the household garbage out in the backyard. They weren't cleaning the house. They weren't maintaining the property. And if a landlord gets a bylaw notice, because it's the exterior of the unit, he has to clean it all up. So he might put you on notice, you need to clean it up by this day, but because he has to meet bylaw standards, he ends up cleaning it up. He can go after you for the cost of that, and only the cost of that. Any more questions?
Yes, we do have one actually. And I've typed it into the chat, I can read it. How is the RJI affected with the Landlord and Tenant Act? Are there any differences?
Okay, so before I answer that, it is, how can I explain? Just because you're RGI does not mean you're not covered by what we just discussed. Okay, please understand that. You have every right under the RTA. However, sometimes RGIs are through a co-op. Now, remember what I want, maybe I didn't mention that. Co-ops, they're a little bit different. They have, like I said, their own set of rules. You have to sort of give a little bit more information, but remember, everyone deserves a reasonable enjoyment of their property. You're paying for it. So just because it's RGI, that makes no difference. What I would suggest is if you look at the Residential Tenancies Act, the RTA, it'll give you a section just under co-ops, if that's your situation. If it's not, then I would say absolutely you're covered under the RTA.
Thank you so much, Rebekah.
No problem.
So far, let me just check if there is any other questions. Seems this is everything we've got for today.
Perfect. I'm sorry, I kind of went a little over on that, but I wanted to make sure that I answered the questions as clear as I possibly could.
Thank you very much. So at the end of this session, I would like to thank you, Rebekah, for being here with us and for this all fruitful and wonderful information you have given us. Thank you very much for your time and effort today, and for everyone who's joining with us today. Thank you very much for being here with us today, and we are looking forward to see you at another session with Rights and Responsibilities Awareness Initiative. Thank you very much, and be well, everyone.
Thank you.